Thank you. So my name is Nienke Grossman. I'm a professor at the University of Baltimore School of Law, and I'm also co-chair of the International Courts and Tribunals Interest Group of the American Society. I'm happy to welcome all of you to this event today, this panel session on best practices in judicial selection of international judges. This event is co-sponsored by the International Courts and Tribunals Interest Group, by the Center for Justice and International Law, or CEJIL, and by the University of Baltimore School of Law. So international courts are deciding disputes which have real and significant impacts on a wide variety of areas of law and life. For example, these include when and how states and non-state actors may legally use force, the distribution and utilization of natural resources, both terrestrial and maritime, how we balance trade and the environment, and the scope of our human rights. Among the courts I'm referring to are the World Trade Organization's dispute settlement body, appellate body, the International Criminal Court, the International Court of Justice, the International Tribunal for the Law of the Sea, the American, European, and the Inter-American, European, and African Courts of Human Rights, and many others. Despite the proliferation of international courts in the last several decades and their increasing importance to the development of international law, much remains to be studied and learned about the selection processes for their judges. For example, what characterizes a good selection procedure for international judges? What elements should such a procedure include? How might it differ or be similar to selection procedures for domestic judges? Should selection procedures across all international courts conform to the same set of standards, regardless of the subject matter jurisdiction of the court? If so, what standards and why? Who should be involved in the selection of international judges? To what extent is transparency an important value in the selection of international judges? So we're fortunate to have with us today three distinguished panelists who come to us with different and rich experiences and perspectives to provide us with some insights into these issues. After I have introduced them, I will ask each of them to speak for a maximum of 15 minutes, hopefully, so that we will then have time for some questions and a brief reception. So immediately to my left is Patricia McGowan Wald, who served as a judge and chief judge of the United States Court of Appeals for the District of Columbia Circuit. She is a graduate of Yale Law School. She was a member of the American Bar Association's Central and Eastern European Law Initiative and worked on constitutional and judicial reform in that region's emerging democracies. In 1999, she was appointed by UN Secretary General Kofi Annan to serve as a justice on the International Criminal Tribunal for the former Yugoslavia, where she was on the trial panel for the first ICTY Srebrenica genocide trial. She has also served on the governing board of the Open Society's Justice Initiative and as co-chair of the advisory committee of DLA Piper's New Perimeter, which specializes in global pro bono projects. She has also been a member of the President's Commission on the Intelligence Capabilities of the United States regarding weapons of mass destruction, and in 2013, she was a recipient of the President's Medal of Freedom. Next to her, we have Viviana Kristisevich, who is the Executive Director of the Center for Justice and International Law. She has litigated numerous cases defending victims of human rights violations before the Inter-American Commission and Court of Human Rights. Additionally, she has taught at American University in Washington, D.C. She has participated in various conferences and training workshops about international protection of human rights in the Americas and Europe. She has published various articles on human rights at the international level, particularly concerning the inter-American system. And she has a law degree from the Universidad de Buenos Aires in Argentina, and a master's in Latin American studies from Stanford, and a master's in law from Harvard. And to her left is Ambassador Emilio Rabasa Gamboa, who is Mexico's permanent representative to the Organization of American States since July 2013. He has served in a number of important positions in the public sector, including as Secretary General of the Mexican Social Security Institute, Director of the Inter-American Center for Social Security Studies, Secretary General of the Inter-American Conference on Social Security, and Undersecretary of Civil Protection, Prevention, and Social Rehabilitation in the Ministry of the Interior of Mexico. In the National Human Rights Commission, he served as legal advisor to the presidency, and he served also as coordinator for the dialogue and negotiation in Chiapas, as a representative of the Ministry of the Interior. He was a professor and researcher at the Institute for Legal Research at the National Autonomous University of Mexico and has taught in various prestigious institutions of higher learning. He did his graduate studies at the Faculty of Political and Social Sciences of the University of Cambridge, and where he also obtained his master's degree in political philosophy. So with that introduction, we'll begin with Judge Wald, then we'll move to Ambassador Gamboa, and finally, Ms. Christi.
Thank you. I should warn you that my remarks are going to be almost entirely addressed to international criminal courts, because that's where I have my experience. But I assume that the other participants here will cover a much broader area than that. So when I ask those working in or with international or hybrid criminal courts, the hybrid being part international, part national, about what they think is the single greatest obstacle to changing what is fairly perceived as deficiencies in these courts' performances and or their credibility, the most frequent answer I get is the uneven caliber of the judges. The judges are the single greatest predictor of an international criminal court's efficiency, reputation, and contribution to the jurisprudence of international justice. Where national courts could not or would not dispense quick and fair justice to the victims of international and civil war crimes, these international and hybrid courts exploded on the scene in the 1990s and early 2000s to fill the gap. But they have been slow and erratic in redeeming their promise. The court's reception among the general populations and with the victim communities has been mixed. They have been criticized sometimes as too slow and expensive, weighted down in legalisms, inconsistent in their rulings, not always in control of their own processes, and meager in their output. No doubt the courts have often been underfinanced, subjected to politically motivated diatribes, but no doubt as well that some of these conundrums are of their own making. And as the focal point of the courts, the judges cannot escape their part in the indictment. Which brings us to the topic of this panel, excuse me, picking international and hybrid court judges, how to do it better. As I say, I pretend to know expertise on the general subject, but I will share some thoughts based on my experience as a judge sitting on both the trial and appellate chambers of the International Criminal Tribunal for the former Yugoslavia in the late 90s and early 2000s, working after that as a consultant to several of the other courts. More to the point, I participated several years ago in a coalition for the International Criminal Court project in 2011, which evaluated 20 nominated candidates for 6 seats on the upcoming election to the International Criminal Court. We were to evaluate them in terms of their meeting the Rome Statute qualifications for jurists on that court. The project itself stemmed from a growing dissatisfaction within the ICC community that the current processes were not producing the best pool of nominations for subsequent election by the Assembly of State Parties, which is the governing body of the ICC. Perhaps due in some part to our efforts, the ASP, that's the Assembly, subsequently set up its own official advisory committee on judicial nominations, which has been following up on our pioneering efforts in later elections. Now, virtually everyone who's addressed the subject of picking judges agrees on the aspirational goals. Judges on international as well as national courts should be independent. That's independent of the political branches and private interests, not of the governing law itself. Scrupulously honest, which we have to admit is not the norm in some countries where it has been the custom to buy your way onto the bench. and morally upright, as well as competent by way of education and experience to make sound legal judgments. But there are additional criteria, I think, that can be crucial in international as compared to domestic courts. Though incidentally, I note that in our own country, here in the United States, there are no constitutional or statutory requirements for the federal judges, not even a law degree. But my own experience judging on both domestic and international courts, however, leads me to conclude that the international judge bears, if anything, a greater degree of responsibility than her domestic counterpart for getting it right, the it being the most appropriate resolution of law, equity, and sound policy. That's because on international criminal courts, there's less precedent, there's no hierarchy of reviewing courts apart from a single appellate chamber to catch outlier decisions, no Congress or legislature to overturn misinterpretation of statutorily based treaties, or in cases of serious malfeasance to impeach the judges. There's less media spotlight. Apart from refusing to pay the bills or changing the court rules or statutes, there are few, if any, outside breaks on international judges, which makes all the more weighty their task of deciding cases that may be the culmination of 5 years field investigation, impact thousands of victims, and involve hundreds of thousands of documents and papers. On the more prosaic side, expertise in court management in this new era of computers and increasingly proficient prosecutors and defense counsel also ranks high among the desired attributes of international judges. Lastly, the fact that they must often operate in conjunction with other judges from other legal cultures who may not even speak the same languages, or at least not speak them fluently, can have an enormous impact on a judge's ability to pursue justice quickly with fairness and dispatch. Of course, all these desiderata cannot be written into international court charters and statutes as requirements for judicial service. The ICTY and its counterpart Rwanda ICTR statutes called only in their charters for judges, quote, of high moral character, impartiality, and integrity, unquote, qualified for appointment to the highest judicial offices in their home country, and that in the overall composition of the court, and when I went on to the ICTY, there were 14 judges, due account, quote, was to be given to experience in criminal and international law. No two judges could come from the same country, and they should be fluent in either English or French, which were the official languages. Judges would be nominated by UN member or permanent mission countries, and 28 of the nominees selected by the General Assembly of the UN from a list of 42 compiled by the Security Council, which was supposed to give this due account of geographical and legal systems. Several years later, the Rome Statute establishing the ICC was much less laconic. It set out an elaborate process for election and spelled out much more detailed requirements for nomination. In addition to the same basic requirements of high moral character and eligibility for high judicial position in the national judiciary and experience in criminal or international law, the Rome Statute added a new twist on how the, quote, necessary relevant experience could be demonstrated. Experience as a judge, prosecutor, advocate, or other similar capacity in criminal proceedings would qualify, or, and this is a big or, as an alternative, quote, extensive experience in a professional legal capacity which is of relevance to the judicial work of the court, unquote, a much broader criteria. This or was further reinforcement in a requirement that there be elections for 2 A and B lists to be compiled from the nominees submitted. A nominee could only be limited to one list only, but states overall had to take into account geography, legal system variations when they were voting, and a fair representation of male and female genders. They may have to change that statute pretty soon. As well as the need for special expertise such as violence against women. These separate A and B list elections have sometimes required several repeats of the process until the right number in each list can get a majority vote and the overall criteria can be accommodated. Yet it must be said in favor of this more complex system that it has resulted in a much greater representation of women on the ICC than at the ICTY or the ICTR. But The evaluation committee on which I served for the Coalition for the International Criminal Court found that even this ICC's more complex selection process, an expanded definition of requisite experience, didn't always accomplish the two principal aims. One, assuring that all nominees understood the fundamentals of criminal law and courtroom procedure, and secondly, lowering the amount of horse trading on non-merit grounds between states that goes on in the election process. That's true of all of the international courts I've worked with. For sure, I had witnessed personally the results of horse trading during my tenure at the ICTY. Sometimes trial court judges had no prior judicial or even courtroom experience, and legal errors, delays, and sometimes reversals were the unfortunate consequence. But even with the ICC system requiring a predominance of criminal trial experience on the trial and pretrial divisions, horse trading has continued. For instance, regional blocs such as the African countries tend to vote together for ICC judges. Candidates are still often elected more on the basis of favors traded by countries than on their individual merits, which of course tends to give the most powerful countries with the most trading chips a thumb on the scale. So what do I conclude from this snatch of history? I think that the push for better judges has to begin inside the countries which nominate the judges. This is a tough assignment, since too many countries in the world have no tradition of independent judges. Thus, nominee evaluation committees such as the ICC and its successor, the ASP Advisory Committee, I think have a critical function to perform in weeding out clearly unqualified candidates. And it's encouraging that the candidates found unqualified by both the committee on which I served, which was obviously just purely outside advisory committee, but the ASP's committee itself, that none of the ones found unqualified were subsequently elected. Unfortunately, there was not that broad a consensus on those that did pass the test. But I would broaden the inquiries that are now being carried on by these official advisory committees beyond paper-based reviews of the minimum statutory qualifications and brief one-hour interviews with the candidates. I would include much deeper contacts with national and international bar associations on the candidates' reputation and experience in their home countries, and not just as to proficiency in criminal law, but also as to work ethics, collegiality, temperament, and managerial ability, as well as language proficiency. Questionnaires, and I think even simulated case-based situational hypotheticals, as well as interviews with the candidates themselves, should be considered. In our federal courts here, the American Bar Association has performed that task of a wider interviews encompassing past associates and employers for decades, and I think on the whole done quite well. But for instance, our committee, our CICC committee, found some candidates deemed qualified by their states under a most liberal interpretation of the B-list definition as having, quote, extensive experience in a professional legal capacity that is of relevance to the work of the court, had in reality the most peripheral knowledge or contacts to the criminal justice system. The Rome Statute's definition of relevant experience covers a lot, too much in my view, and does not approach guaranteeing a competent judge even at the appellate level. Under the Rome Statute, there has to be a predominance of courtroom experienced on the trial and pretrial divisions, but the B-list types can serve on the appellate levels. I'm somewhat skeptical about the wisdom of that kind of dichotomy, since in my experience, both as an appellate judge here and on some appellate designations that I had at the ICTY, I found that the appellate courts must review the decisions of trial judges on complex procedural issues as well as probe larger conceptual questions of international law. And some of the recent troubles at both the ICTY and the ICC are perceived to be caused by appellate judges who simply don't understand the limits of their own reviewing jurisdiction. So in the end, I think in a court whose jurisdiction is exclusively criminal and fairness of procedure is a prime requisite, on-hands experience with criminal trials should be a requirement for a majority of judges at all levels, albeit with a minority at the appellate level also required to possess international law credentials. Again, I point out my own experience has been with War Crimes Court. I recognize, as you pointed out in the introduction that there are international courts whose subject matter is not solely or even predominantly criminal, and these may well place greater emphasis on specialized knowledge and experience in maritime law, trade law, or other areas of civil law. There is no, in my view, size that fits all. But in the criminal courts, which deal with liberty and freedom, I tend to remain committed to a firm requirement of criminal proceeding experience. And even within that area, the qualifications may vary as well. For instance, the skills necessary for an investigating judge in a civil law proceeding who basically runs the pretrial investigation may be much more refined than for a judge on that same court who tries or reviews the charges. At a deeper and more difficult level, national leaders, I think, must be continually impressed with the need to send top candidates to the international courts as a means of enhancing their own country's international profiles as well as the court's welfare. A long-range education project for sure. But now the question invariably arises as to how to impose quality control in those countries where the executive exercises total power over the nomination process and may be likely to appoint only those in his or her political favor, and where there's a deeply rooted tradition of, and this is true in some cases, unfortunately, a deeply rooted tradition of corruption in judicial appointments, including to the international or hybrid courts. Mark Ellis, in his enlightening study of War Crimes Tribunal, has cited Cambodia as one example of where recurrent delays and impasses are due in part to the monolithic nature of and lack of transparency in the nominating process. In such unfortunate situations, he recommends that the evaluation committee mechanism, as well as an independent and transparent judicial appointments committee affiliated with the International Court itself and composed of international experts and judges, NGOs, and academics, should evaluate the nominees. Just a few more points and I'll be through. Training is another avenue to better judges, but in honesty, while it can be an essential and valuable step in acquainting new judges with the particular variations in rules and procedures in a particular court, I don't think it can supplant the kind of interactive, instinctive, and intuitive knowledge about criminal procedure and law that comes from long time and substantial familiarity with criminal proceedings. This is especially true in the elusive area of judicial ethics and misconduct, a specter which has haunted some international courts. I'm not familiar with the judicial training protocols in current use. There were none in my day, but I would think that there should be a kind of CLE, continuing legal education, to account for new dilemmas which are constantly arising in new courts who do not have a long history of dealing with problems. Now, very quickly, as time is closing in, I want to mention three other aspects of judicial selection that are susceptible to producing vulnerabilities or inappropriate influence on the conduct of judicial proceedings, and so to affect the credibility of the courts. One is age limits. A majority, this is controversial, I know, but a majority of democratic countries do have them for their domestic courts in the 70 to 75-year range. The United States does not for federal judges, but many of our states do. Perhaps ironically, given my own advanced years, I do favor age and term limits for at least those international courts where the terms themselves are extensive and renewable. The CICC committee on which I served recommended serious consideration of age caps for the ICC. At the ICTY, I did see instances of aged jurists who were simply not up to the job and whose legal assistants became, in effect, de facto judges. The lack of any age limit, together with renewable terms of long duration, also, I think, or I found, made for undue influence by one or a few judges who were more likely to attain the presidencies of the court. The prospect of campaigning for successive terms also could consciously or unconsciously affect a judge's devotion to and concentration on cases at hand. The ICC has a single non-renewable 9-year term, but at the ICTY, judges could and did go on indefinitely in my time, not always a good thing. I realize this opinion goes counter to a long-standing view in the United States that federal judges' lifetime tenure is a guarantee of their independence, but my own 20-plus years on the federal bench does not support the view that they are necessary for that purpose. And I note in recent years there have been respected voices raised here at home as to potential problems of judicial stagnation that long terms and lack of turnover may raise. Now, an aspect of most international courts that I have strong feelings about is the power conferred on presidents or chief judges of the courts as to assignment of cases and individual judges to panels, both trial and appellate. Generally, these chief judges are elected by their colleagues, but again, seniority on the court due to tenure gives the most senior judges a distinct advantage in that. The assignment power accentuates the power of the chief judge. I have seen it at work, and moreover, it provides an unnecessary and unwise vehicle for him or her to bless favorites, punish opponents, and candidly in that process influence in reality or in perception the outcome of proceedings. In the D.C. Circuit, on which I served as the chief judge, the law provided for a 7-year term determined solely by seniority in the court, but available only to someone under the age of 65 and terminating at 70. Chief judges did not assign cases or judges to panels in particular cases. This was done by software programs overseen by the clerk of court, and that neutral assignment system worked, in my view, very satisfactorily, particularly in a court, and there are some in the international court, that had strong substantive differences among its members. The ICC statute requires that initial assignments to the trial, pretrial, and appellate chambers are made by the president and vice presidents, taking into account the statutory requirements of criminal law experience predominance in the trial courts. But make no mistake, the power to assign choice cases to a particular panel or judges, to particular chambers, or to the trial or appellate panels is a powerful tool in court dynamics and can be easily misused. Some of the international court's credibility has suffered from suspicions that the assignments reflect personal likes and dislikes, not objective merits. Although there may be statutory obstacles to change in this regard, it is not out of the realm of reason, I hope, that chief judges or presidents could be convinced that it's in the best interest of the court's reputation and integrity to adopt on their own a neutral, even automated, as we had, system of assignment. In closing, I apologize for having no solution to the horse trading that goes on in picking judges on international courts. The justifiable demand for geographical and legal system representation, as well as gender diversity, slide too easily into trading on bases not involving individual judges' merits. The only possibility I can even think of, apart from clear, just plain enlightenment, is that if a kind of 5-year plan or schedule could be agreed upon in advance as to which countries or regions will be represented, horse trading in the interim years could be lessened and selections made on the basis of whether candidates' individual merits meet the grade. In any case, however, we do have to keep trying to get better qualified, in all the respects I noted, judges onto these important benches so that the international courts can claim their rightful place as the prominent instruments of international criminal justice they were conceived and designed to be. Thank you. I hope I didn't go too much over time.
Thank you. Thank you. Okay, now we'll turn to Ambassador Ravassa Gamboa for his remarks.
Thank you very much, Nikki Grossman, for your presentation. I certainly feel honored to be at the table with such distinguished panelists, and even more so to be in gender minority, which is something that has to be thought of in considering your very pertinent question, which is what characterizes a good selection process for international judges, which was posed to us by Professor Grossman in inviting us at this panel. And I think it's a very pertinent question the way it was phrased, because it does not only consider the subjective or personal qualifications, which is, has been for a great extent of time the main selection criteria for judges, such as having a law career or, and certainly, moral authority, experience, etc. But because it also includes another element which nowadays becomes relevant, particularly in the case, and I'm thinking, of course, of international courts, particularly the Inter-American Court of Human Rights, which is the composition of the court. So we have to find a solution, a scheme that combines both the personal subjective element with the diverse composition of the court. In my view, a good selection process is first and foremost a process in which each and every one of the candidates competing is fully qualified to act as a judge of the international court at hand. By fully qualified, I mean candidates at least meeting the minimum qualifications required by the tribunal rules. Individuals with personal virtues such as high moral character, impartiality, independence, and integrity, but also persons with sound academic background, recognized professional experience, and technical skills on the subject matter of the international court's jurisdiction. And as many international courts require, having those qualifications required for the serving in the highest judicial offices under the state law of their countries. Secondly, a process in which there is available and accessible information on the candidates' qualifications, on their general vision of the international court or body they aspire to sit at, and their opinions on relevant topics related to the court's subject matter jurisdiction, without compromising their eventual position as judges, and as well as we call them, on their work plans and on the proposals to strengthen for court's work. And moreover, a process in which all stakeholders have the opportunity to meet, interact, and pose questions to the candidates on all the terms I just mentioned. The recent election as Supreme Justice of the court in Mexico now Justice Medina Mora is a case worthwhile of studying because it really involved a great deal of debate, a great deal of information on his curricula, on his merits, on his life. And I think that was very healthy for, for my country. I don't think we had experienced such an election process so vivid in all the requirements, where many people gave opinions inside the Senate, outside the Senate, and information on his agenda, on his qualifications, was a very valuable element. Thirdly, a process in which the selection of the judges is solely based on the candidate's merits. And lastly, a process able to ensure an inclusive bench of sitting judges, a bench striking an adequate balance of women, men, persons from all social groups, from different legal traditions and different legal specializations, and from all regions under the court's jurisdiction. In sum, a good selection process is one where, one, highly qualified candidates compete, two, there is a publicly available information on them and the possibility to interact, three, there is a merit-based election, fourth, an inclusive composition of the court is ensured. This is precisely what we should aspire for every selection process of judges of international tribunals. And I believe there is a lot to reflect and debate upon towards that goal, both at the international level and the corresponding political organizations and/or bodies and nationality. Within our countries, in other words, how can we improve our current selection processes for international judges? These domestic and multilateral debates, I believe, should be informed by an assessment of the good practices we already find in certain countries and at different international tribunals. Good practices primarily oriented towards those ideal characteristics we identified. We need to assess if they have worked, what improvements need to be done, and actively foster them. There are countries, for example, in order to select persons to be candidates for tribunals or treaty bodies, have implemented open selection processes, which are publicly announced along with the criteria to be met, and allow submission of potential candidates by everyone interested, followed by interviews. This is actually something that the Parliamentary Assembly of the Council of Europe the one charged with electing judges of the European Court of Human Rights, has recommended to states for their candidates' nomination processes. In fact, the same Parliamentary Assembly established a procedure for interviewing candidates to the European Court, carried out by the subcommittees on election of judges as a mechanism for verifying the merits and skills of the candidates in relation to the working languages of the court, candidates who must also have proven experience in the field of human rights. We can also find many good practices at the International Criminal Court. The Assembly of States Parties to the ICC requires that states making nomination must submit a note with the information evidencing that the candidate meets each of the requirements indicated in the Rome Statute, including specific experience and knowledge. All candidacy with the notes from the states are published on the ICC webpage. On December 12, 2014, the Advisory Committee on Nominations, foreseen by the Rome Statute as an independent organ to review the candidate's resume and monitor the election process, finally began operations during the election process of 6 judges to the ICC. The ICC requires candidates to have experience in criminal and procedural law, and as a judge, prosecutor, litigator, or the like, or have experience in the areas of international law relevant to the court, international humanitarian law, and human rights law. The Rome Statute goes further and provides that states must take into account the need to include judges with legal expertise on specific issues, including but not limited to violence against women or children. The Rome Statute provides further that states, when electing judges, must take into account representation of the main legal systems in the world, equitable geographic distribution, and balanced representation as between men and women judges. The Assembly of States Parties to the ICC has issued specific rules that instruct the states to vote for a minimum number of candidates from each regional group and gender. At the international level in 2013, the Permanent Council of the Organization of American States organized and held what was called the Forum of Candidates, in which the candidates nominated by 5 member states, Mexico, Brazil, Colombia, Peru, and the US, to the Inter-American Human Rights Commission presented to both states and civil society their qualifications to act as commissioners, their views on the Commission's work, and their work plans and proposals in the case of being elected. All candidates addressed also questions posed by states and civil society. Another positive development was registered at the United Nations General Assembly, where a resolution on strengthening and improving the effective functionings of the system of organs created pursuant to human rights treaties was approved, which encourages states to continue efforts to nominate experts of high moral standing and recognize competence and experience in the field of human rights, in particular in the field covered by the relevant treaty, and as appropriate to consider adopting national policies or processes with respect to the nomination of experts as candidates for human rights treaties bodies. All of the examples above, and many others out there, will provide to be completely useful for the debates and reflections that are needed to be more actively promoted and held, like this seminar right here. And we need to be able to devise and discuss viable and creative solutions to improve gradually and on the basis of consensus our selection process. It is definitely not an easy task to achieve all these objectives, but we ought to keep advancing efforts. Thank you very much.
Thank you. Okay, Viviana Kristisevich.
Thank you very much, Professor Nienke Grossman. I'm especially grateful for you for convening this panel. I think the discussion is very timely in the area where I work in, the Inter-American system and at the OAS, but it's also important and timely in other fora. And I'm obviously very honored to be in the company of such distinguished panelists, all of you. So I will divide my presentation in two sections. The first part of my presentation will be devoted to talking about why composition of international tribunals, mechanism, and adjudicatory bodies matters, and its particular significance in the international arena. I will be drawing from primarily my experience in human rights courts and mechanisms. And second, I will deal with the selection processes of these tribunals and adjudicatory bodies that we consider are essential to determine the composition of the tribunals and the bodies, but also for the legitimacy of those organs. I will discuss aspects of process and substance in terms of the nomination and the voting in the selection processes of tribunals. So let's go to the composition. I think that Judge Wald was saying how important and stressing how important composition and who are the members of the tribunals is for the credibility and the efficiency of a tribunal. Composition matters because it depends, it shapes the expertise, the competence, the outcomes, and the social legitimacy of the body. And in that way, it impacts directly on the authority of the tribunal. Who are the members affects the set of skills available, the training, their expertise, and in turn, it has a very direct impact on the types of decisions that the tribunal comes up with. We can see the examples of tribunals where you have common law and civil law lawyers, people coming from different experiences, and how those different areas of expertise and training and set of skills that they have can actually result in a very distinct outcome. And the relevance of the candidate's skill or expertise is really not a controversial idea in looking at what is important in a tribunal. But when we try to analyze other factors, when we think about life experiences, gender, sexual orientation, race, disabilities, geographical representation, there is more debate about how these conditions or situations can shape the decisions or whether they hold any bearing over the specific tribunal or mechanism. Are they pertinent considerations in specific mechanisms? And for many, and probably because of our training, many disregard most of these categories as irrelevant, considering them suspect. And given the diverse experiences of people based on gender, nationality, race, I'm not making an epistemological claim that we are all going to decide in the same manner because of a specific situation or condition. However, in some contexts, the diversity of experiences and expertise might actually have an impact on the type of decisions and solutions found by tribunals. And it also can be very important not only because of the diversity or the different solutions that diversity can shape, but also it might be relevant for the parties, for the affected community that is at the receiving end of the decision. And that's a point made by many scholars, including Professor Grossman. So even if you didn't believe that it really mattered, diversity, maybe it mattered for those receiving the decision. And this is a critical aspect because composition might impact the perceived legitimacy or fairness of a decision. And I think in some contexts, it is possible to argue that decisions issued by a body perceived as more authoritative or legitimate might have more of an ability to catalyze change and to be more effective. And why is this important in the international arena? At least this, I think, is very important in the human rights arena, but it might be interesting for other tribunals. I think that in international tribunals and mechanisms, much of the normative and social legitimacy is taken for granted at the local level, has to be constructed. And observing international tribunals, special procedures, human rights bodies, we can identify a reliance on a set of dynamics that ensure the execution of judgments and the impacts of decisions that hinge a lot, that are based on the perceived legitimacy and authority of that body. And that is a social and political construct. So legitimacy can be decisive. And when you're asking about legitimacy, you might ask yourself, legitimacy to whom? How can this be, to whom it has to be relevant? And in many decisions, especially in human rights tribunals, do not only have to be legitimate to the parties that are involved directly in the litigation, but they have to be perceived as fair and legitimate to other actors within the state and non-state actors that in turn will be the ones that will walk the walk. They will be the ones that will actually make it happen domestically, that will make the changes that are necessary so that the decision is implemented. So for example, many decisions of the Inter-American Court need the judiciary to act. It might be the foreign ministry that is litigating, but if the judiciary doesn't do what the court said, then you're not going to get full implementation. So a mayor, or it can be the victims movement, or the NGO community that can be relevant. So it's state and non-state actors that might be relevant. And also, decisions also have to be perceived as legitimate sometimes by the collective group of states. So they have to make sense not only domestically to those that are involved in the litigations and those that are critical for ensuring implementation, but also they might have to be legitimate for the broader group of states that are part of the community that will be impacted by the jurisprudence of a body. And so, are these conditions of legitimacy relevant for any tribunal? For example, with the Tribunal on the Law on the Sea and the Inter-American Courts of Human Rights, should they worry equally about gender balance? No? And I think that there might be areas, I don't know anything about the law of the sea, and so, but I assume that in many areas of the law of the sea, gender might not have an impact in the decision. However, if you look at a tribunal, an international tribunal, any tribunal, considering that there are so many incredibly accomplished women judges, academics, practitioners, the fact that you have an international tribunal in any area of the law that doesn't have some level of gender balance and diversity should make it suspect. Should make it suspect of a democratic deficit in the process of selection of the members of that tribunal. Unless there's a problem in the pipeline that we don't understand. But I think in principle, it affects the legitimacy of any tribunal. But I think in the case of human rights tribunals that are founded on the principle of non-discrimination and equality, having a human rights body fully composed only by men and lacking any type of diversity is highly problematic. In a study that we're publishing as part of an upcoming campaign on gender parity in international law and international representation, we have come up with some of the numbers of gender representation and women representation in different international law tribunals, hybrid tribunals, international criminal law tribunals, and human rights bodies, and the numbers are appalling. You probably know the scholarship and the incredibly interesting pieces that Nienke has produced, and we hope to build on that, and we're doing some of the numbers that I can share with you, but some of the most appalling are, for example, in the Tribunal of the Law of the Sea, out of 40 members that they had historically, one has only been a woman. And in the historically, the members of the Committee on Civil and Political Rights, 13% have been women, and you can go on and on. The Inter-American Court on Human Rights, if you look at a picture of it, it has no woman and nobody from the Caribbean. There's no common law lawyer that informs the decisions of the Inter-American Court, and there has never been anybody with an indigenous background or self-identification in that body. So I think that for human rights tribunals, legitimacy is critical for effectiveness, as I said before, and it is very problematic. The lack of diversity and gender parity, I think, is the tip of the iceberg of an international system that has a serious democratic deficits in their selection processes that really need to be addressed. And so I go on now to the selection processes themselves. And I want to distinguish between nominations and voting processes. The selection processes, including nomination and voting, are decisive for the legitimacy, authority, independence, competence, trust, and eventually impact of the different bodies. Nomination processes can be much more transparent and participatory. This is something that was addressed by both speakers, but also there could be significant steps taken so that the competence, diversity, integrity, independence are also guaranteed, or at least the bar for participation is higher. The nomination processes are, well, at CEGIL we have worked a lot on the nomination processes for the Inter-American system, and so I just want to make sure that you all see this document that we did with contributions from Nienke, a professor at La Sorbonne, the former president of the Inter-American Commission, our colleague Alejandra Vicente, who's here, and one of our colleagues from Amnesty International. But in terms of the nomination processes, a lot could be done to increase the transparency and participation in the nomination processes. And this, we understand, will impact in having a broader group of candidates, a more interesting discussion of the necessary qualifications, and a process that is perceived as non-arbitrary and where merit plays a part. There are important experiences in the Americas and in Europe on how to create a more transparent and participatory process. Amongst the proposals to be taken at the domestic level, there could be listing of positions and opening of vacancies, asking for proposals of qualified candidates in an open manner or through civil society organizations or professional associations. The states could define the priorities that they had for the specific nominations and desired qualifications for the positions. The executive could actually, the foreign ministries could justify the decision once they nominate a person or make a decision on who are they going to nominate and why. There could be policies for parity and diversity that could be taken domestically. And at the level of international institutions, there are also many things that international institutions have done and could keep on doing to increase the transparency and participation in the nomination processes, posting the available positions, asking about how the persons were nominated domestically, creating these formal procedures, as Judge Wald described, of advisory panels. Actually, I want to announce here to my colleagues that there has been a panel of high-level independent jurists that was established a couple of weeks ago to review the nominations of candidates for the Inter-American Commission and Inter-American Court as an initiative of academic institutions and civil society organizations and foundations that we hope will also come to play a part in the OAS. We think that that's a very important experience. And but we think that for nominations and for voting, there also have to be there should be some steps taken so that there is some level of evaluation of the competencies and skills of candidates, either through review procedures that are participatory. I don't really like very much the review panels that are very closed of highly important experts, but that do not have the input of different sectors of the societies and academia, because I think they can also replicate some of the problems at the international arena. But this is something to look forward to. And in terms of the voting process, I think that there are a couple of things that I just wanted to highlight, and we can talk about this later. One is how to tackle the issue of horse trading and the lack of sophistication of the collective voting process, that in order to ensure the requirements, the formal requirements set in the treaty, statutes, guidelines, or national policies. I think we can do better. I actually hope we can do better. I think we have a duty as the community interested in international law to rethink the collective voting process to ensure certain desired outcomes that are critical for legitimacy. And I think we can. The ICC is an example. There might be other examples in other areas of the law and of international relations of creating voting systems that can secure gender balance, geographical representation of different legal systems, and the necessary expertise, integrity that we all look for in candidates. And I wanted to ask a couple of questions just to finish and to spark the discussion. Just why is voting for candidates secret? Why couldn't we have the votes known to everybody? I think that there's a lot, it would be very interesting to know who's voting for who in terms of international tribunals, and how our own countries are, not only nominating but also keeping the pledges of voting for the best candidates. Could that be a way of, as well, limiting some of the horse trading? And are there disadvantages and advantages to such a discussion? And my last point is, why can't we think of systems of looking at tribunals, as collective endeavors? I always grapple with that when seeing how states vote. They vote thinking of the individual candidate, and sometimes they don't think of what does the court need. Do they need somebody that knows about case management? Do they need, what are the different, not every judge has to be equal to the other judge. They might bring different things that are absolutely necessary for the development of the work of a tribunal. And that collective view of the skills that are necessary for a tribunal is absolutely lost as well in the system that we have currently. So thank you very much for the patience and for the opportunity of participating in such an interesting discussion.
Okay, well, thank you very much to our three distinguished panelists. Before we open up the floor for questions, I'm going to monopolize the conversation for 1 minute by asking my own question, which is, in my own research, I've been struck by certain reforms that seem kind of obvious, certain things that you would think would be obvious to include in a selection procedure. So for example, having a standardized CV, having a group read it and considering whether it meets the qualifications requirements, which we see on some international courts. For example, the European Court of Human Rights, which was mentioned before, and the International Criminal Court have done this. But then we have many courts that don't have that, like the International Court of Justice, the Inter-American system, and the International Tribunal for the Law of the Sea. There's no screening of any kind to sort of see whether the qualifications and the candidate meet. And so I wanted to ask you why we haven't undertaken kind of the more obvious reforms, or a different way to ask the question might be, what are the incentives for states to maintain the procedures as closed and tightly controlled as possible? And is there, room to kind of overcome that incentive or not?
Well, I'll take a stab at it.
Okay.
I think, from what I can see, over the last 20 years, or since we've had, at least in the era I was talking about, international criminal courts, I think it may have gotten better. When I was on the ICTY, what was happening, quite frankly, in many cases was, it was a new court, and people were not sure whether it was going to last. And so there was a tendency for some of the countries to nominate people, which was like a reward. Old Joe, he's been a good guy, domestically, and now we'll put him out to pasture. We did have several of pasture candidates, in my experience, over there, and who, just not up to the job at all. Never been in a courtroom before. They may have been a good person in a bureau of the UN or something, but in a criminal court especially, you're dealing with life and death kind of thing. I think that's gotten better, because we've all pointed out the ASP has set up the committee after we did it on an experimental basis for the CICC. But I think, again, and you pointed out, and all the speakers have pointed out, I think the inquiry by these committees has to get a little deeper, something akin to, Mark would remember, the ABA. They get, people get mad at them sometimes for digging around too much. But actually, I think on the whole, and I think we can get much more sophisticated. For instance, I've heard some people suggest things like not just have a questionnaire where you do it, or even an interview, a 1-hour interview with the person, but almost like a forum, in the sense of a simulated kind of thing. Well, if this kind of situation came up, what would you think ought to be considered? Or, what do you think are the, somebody has referred already, might be the most important problems that this court is likely to meet over the. And the other thing I just want to stress again, I mentioned it before, but in this area I'm talking about, and we're seeing some equivalent in the area that I'm now working in, which is national intelligence. It's not the old court, and the old judge for the court isn't, maybe as happened in a lot of domestic courts, especially maybe in smaller countries, did this person do violence to that person kind of thing. You are talking about how you ran a military operation over 10 years and with tens of thousands of people in it, what the lines of control were up and down so that you can assess responsibility. It is the equivalent of running an agency, not just a kind of, let's look at the evidence and see if this is this. And so I think, you know, what you need are the kind of, especially now with technology, you know, you're really fairly sophisticated not in every court, but I would guess some of those civil cases, civil areas where they have it. So I think the kind of things we're looking at have to be better. And you pointed out the secret thing, which I think is very interesting because, look, in the U.S., we confirmation processes for judges are open. I know I've been there, done that for maybe some people say too much so that it discourages some candidates from even trying. But still, on the whole, there's really no reason why something should be secret, because then I think a person should have to express themselves and say yay or nay on that. So that's I think okay, that's all.
I'm not a state representative, so I don't know really why is it that states don't do it. I think that is under the theory of, it's a very anti-democratic practice that comes from inertia and lack of accountability. You know, they have the possibility of not consulting with anybody and not having to deal with having to check these things with different constituents, and they don't do it. And so I believe that in many cases, not only we have tried to work on reforming some of the processes, but we've talked to, I don't know, dozens of candidates over time, and how were they selected and how they approached the position and who approached them and how that happened. And a lot of that is collegiality. I don't know, like, I don't really know how. When I think of women in international law and about the problems of women accessing these spaces, I was thinking today that there's not a problem of the pipeline in terms of the group of women, but sometimes it's like who's friends of whom, you know. So there's not a problem with the pool of people, but maybe there is a slight problem with the pipeline. And I think that the pipeline is a group of people that talk among themselves, and sometimes it's a question of favoring somebody that is a friend of yours or a group that is close to you ideologically or politically. And some of those people are remarkably good, actually, for the obscure process that many countries have for nomination of candidates. It's actually a reasonably good pool. But I think that has to change and will change. And because there's a demand, I think, domestically and internationally, especially when these tribunals now have an impact in so many countries in such decisive things such as, I don't know, the way in which military jurisdiction occurs, or, you know, if amnesties or can be granted after peace processes, or, you know, how you deal with equality. So people are asking in the press, in different political processes, but who's deciding and why, and who are these people? And so I think that there are lots of democratic practices domestically that could very easily, without the executive losing the power to eventually make the decision, they could permeate differently. But it will also depend a lot on the community around them, asking for more structural changes and criticizing them when they are not consistent with the processes and with the actual candidates that they put forward.
Ambassador, do you have any remarks?
Very briefly, so we'll have more time for more questions, but I think that the whole process is in a process of selection of judges. It is certainly in a process of change. If we compared how were for example, in the Inter-American Court of Justice selected as the new ones that will be selected this year by the General Assembly, there are new elements like elements that fight against the traditional ones. Which are the traditional ones? The trade-off. I think we have to avoid, by all means, the trade-off. That I give you the vote for this candidate in exchange for you voting for mine in, not even in a tribunal, but in any other organization. No? That should be avoided, because that completely forgets about the merits, forgets about the composition of the court, forgets about all the elements that I mentioned in my paper. No? And it only rests on, on the exchange of votes. That has been, it's being superseded by other elements, but not completely. This is why I think is one of the reasons why the process is not all that open as it should be. Because if it was completely open, that should be completely avoided. But on the other hand, there are new elements, like, for example, in the case of Mexico, we have now required the candidates to go to Mexico, to talk with the authorities, not only with in the foreign ministry, but also in the Ministry of Interior, in the General Attorney's Office, with NGOs, etc. So we get to know more about them. And we have established that requirement to all our member states that have presented candidates, that from just about a week ago until before the election, we will welcome them to go to Mexico and get to know about it. So that is the second element that I mentioned in my paper, that is information about them. So it's in the process of change. It hasn't completely gone through a more objective, open, professional process. There's still this element of trade-off in it, and I hope that with more involvement, such as this forum or others, the process will completely change in the future.
Thank you very much. Okay, so we have time for a couple of questions from the audience. Yes, Mr. Golden.
Yes.
If you could just identify yourself on the microphone, because we're taping this this proceeding to share with other interested people in the future. So
I'll do that, Professor Grossman. But before I do, I just want to compliment you and the panelists. This has been terrific, and I hope the papers are either going to be published or somehow otherwise available to us, because this is an important topic. As you say, things are changing and it won't go away. My name is Jeff Golden, and I have the privilege, I'm going to get to I think, a short and straightforward, if not simple, question. But in order to help you understand my interest in it, let me give just a little bit of background. I have the privilege of, and expand maybe the concept of international judge or judging in international tribunals. I have the privilege of chairing a foundation in the Netherlands called Prime Finance, which is partly a part of a response to the recent financial crisis. Prime stands for Panel of Recognized International Market Experts in Finance. And it, among other things, stands there to settle disputes, complex product and financial market disputes, and it has a panel of experts, just over 100 in number, who collectively have more than 3,000 years of relevant experience. So the question of how do we select experts for that panel, and how do we preserve, this one is all about people, all about the market and the public's view of the caliber of the people who will judge these cases. And it's also about putting together tribunals which collectively, where the whole is greater than the sum of the parts. It's putting together legal experts with market experts, judges with lawyers and academics and regulators and the like. That's one reason why I've got an interest in this, but the other reason is more than 40 years ago as a student, this topic was the subject of my graduate research and thesis, some of which I did here at ASIL. Research was inspired at the time and it was focused on the International Court of Justice, the PCIJ that preceded it, at a time when there was not a single case pending at the ICJ. And the question was whether if we did a better job of selecting and recruiting the right judges to the process, that might be different. And one of the issues that engaged me then, one of the questions that I had to wrestle with and asked a lot of questions of others more knowledgeable about, was when you had to choose whether it was easier to teach, because there's a tribunal, the ICJ, that applies international law, whether it was easier to teach a judge international law or an international law expert or professor or academic how to judge. And there was a huge divide in thinking, largely between common law jurisdictions and civil code jurisdictions. But it also, I found, became a more complicated question because when it got down to the practicalities of actually getting someone to move from New York or Washington, D.C. or other major centers to The Hague, sometimes academics were more willing to make that move than judges. Sometimes it was hard to find the person who you otherwise might have thought of as ideal for the job to take it on. So I guess that's partly my question. With our project in The Hague, it's very important that there is competence in the subject matter. It would be very difficult for someone in a short period of time to really get up to speed for something that others have spent decades wrestling with, which is in minds of some rocket science and very hard to reverse engineer. But I guess that's a question for this panel. When you have to choose, when you can't just find the ideal candidate, when you're trying to diversify and get a whole which is greater than the sum of the parts, to what extent do you choose the judicial experience that Judge Wald said has been so valuable, understandably, in a criminal law context? Do you choose that over and above the technical expertise of the subject matter?
That's your question?
That's my question.
I would just repeat, and I'll be brief because I already said it. In the criminal area, it seems to me that you very much want to give predominance, which actually even the Rome statute does, to a real criminal justice experience. My experience, 20 years plus in the court here in the D.C. Circuit, which got a lot of administrative law and regulatory law and a lot of very specialized kinds of cases. And then over there is that you I don't want to sound kind of, way up in the clouds. There is almost something you can't even articulate if you've been in a court a while. I mean, that you understand how the parts of the court are supposed to relate to each other. And especially, I think that's true between the appellate and the trial courts. I mean, I was a trial court at The Hague and an appellate court, primarily in an appellate court for 20 years here. And I think a lot of the trouble with the international criminal courts, when they've had it, it's caused delays. I mean, there is no reason on earth, I think, why an appeal in one of these international criminal cases has to take years. I mean, we had complicated cases here in the D.C. Circuit, and I think it never took more than a year or something, or in all my time, to get something out of there. I mean, the whole feel for what the appellate function was, and that's causing a lot of trouble, I'm told, at the ICTY, because after a while, a court is, I don't want to sound smoozy now by saying it's like a family, but it's like an institution. It has to work together, and the trial judges have to have a feel for what their jurisdiction is versus what the appellate jurisdiction is. And sometimes when you get people who don't sort of understand what a court is about, they will do stuff at the appellate level, like they'll take and reopen the whole case and, and just decide everything from scratch. And it drives the trial judges, insane. Also, it just makes for chaos kind of thing. So in the criminal area, because apart from which I think in the International Criminal Court, and in in the ICTY, there's no way you could have expertise in the kind of stuff that came. I mean, you could read a lot of military history, I guess, but when you get, questions of massive killings and genocide and command structures that going up, there's no way that somebody's going to come in there as an expert. I think it really, you got to somebody to understand how you take the most cogent principles of criminal law, be they civil or adversary system, and translate that into a massive happening. And I don't, so that, it might be very much be different in the law of the sea.
Maybe I'll throw in something too. My own background is more in the International Court of Justice, and it's interesting there because there is no appellate body whatsoever. So it's a trial court, which many people say, and as I'm sure you saw in your own studies, is composed of people who are not trial judges. And this has come up, for example, in the context of environmental cases. How should these judges handle cases with complex environmental facts? And this was the subject of a panel at the annual meeting, just a few weeks ago. And so when judges don't have that expertise, what kind of reforms need to be undertaken, or what kind of mechanisms can be established to deal with that lack of expertise? So, one of the things that came up on that panel was that perhaps there could be you could have a group of experts to decide certain very technical questions that might come up. But in a court of general jurisdiction, general subject matter jurisdiction like the ICJ, this is an even more complex question in a way.
Let me just add a footnote to that, because the ICJ, for instance, when the Srebrenica case that I tried with two other judges and a panel of three, took 1.5 years to go from beginning to end. But this, you're talking about something where 8,000 people were killed within a week and were scattered in massive graves all over, and we had 100 and God knows how many witnesses and thousands of them. And we were trying it in tandem with another case. So we do 2 weeks on one case. Anyway, so we did get all that. When the case of, was it Bosnia v. Serbia or Serbia v. Bosnia, came over to the ICJ, they do not have the fact-finding, but they, if you remember, relied heavily on the fact-finding that we had found in the ICTY, on not just that, but on the prison camps too, which I also was in one of the prison camp cases too. But I think it's a real detriment. I'm sure they can solve it, but some of these cases, how you could, decide that Bosnia v. Serbia and not have any fact-finding. Not ever, have the witnesses. I don't care how many history books you read, they're all going to say something different, or how many lectures you had about that particular conflict. I think that, I thought that was very interesting, because they relied very heavily for their fact-finding on what we had actually found.
If I understood correctly, your question, which I find very interesting, is what would be of more weight, the expertise or diversity versus diversity, and not so much expertise. If that is the question, which is a very interesting question, you had asked me some years ago, I would have replied expertise, that the incoming judge would know, would have experience in the matter that he would be judging, human rights, commerce, criminal justice, whatever. Nowadays, I would answer differently. I would answer diversity. I think it is much more important that a tribunal is built with different outlooks, particularly, for example, in the field of human rights. You have to include gender. It's very important. Unfortunately, as Vera mentioned before, the Inter-American Court of Justice are all male judges. For the first time, there could be a woman from Costa Rica, Professor Odio from Costa Rica, and that is very important. Then you incorporate truly a different view in judging. Let me give you two cases which I think will justify what I'm saying. My own wife is a judge in Mexico in the Federal Electoral Tribunal. The Federal Electoral Tribunal, which is part of the judicial system, is composed of 7 judges. There are all 6 men and 1 woman, only her. And it was until she arrived in the tribunal that the general criteria was incorporated in sentencing. It was she who was able to pass a resolution in the tribunal to confirm that all political parties had to register 50% candidates, women and men. The so-called quota de equidad, equity quota or something. Equality quota was called, which was very strongly resisted by leadership in some political parties who thought that there wasn't enough women to represent them in Congress. For the first time in Mexico history, now we are having a almost 50% gender composition. But it was a woman who had to be there and convince the other 6 that it was a necessity of the country to pass that resolution. The other case is what I just mentioned just a moment ago of Justice Medina Mora. He has certainly no experience as a judge, and that was brought up during the proceedings, the hearings, sorry, in the Senate and the interviews, etc. But he has a great experience in matters of security. He had been Attorney General, he had been Ministry of Security, and he has also expertise in international matters for being ambassador to London and the United States. And I think this is important for a court now in Mexico, to incorporate those criteria. So put it in the balance, I would now go more for diversity than technical and competent skills, although within certain bounds, of course.
Sure. Because we're running over our time, let me just give Viviana a chance to say something, and then if any of the panelists have anything else that they have a burning desire to share with the group, I will give them the opportunity to do that. And if not, I encourage you afterwards to please continue the conversation. Go ahead.
I think that, as you were saying, sometimes you have to think of the parts and the whole, and how sometimes the whole has to be more than the parts, and what are the necessary requirements, or a reasonable rock band or soccer team or international human rights court, and might be slightly different, and you might need people to play different roles or have complementary skills. And so I wouldn't say that in the human rights context, I could say that necessarily all the judges of the court or nominates have to be judges. Especially, I think, coming from the region that we come from, there's like 98% impunity, and the justice system in many countries is a failed justice system. So the pool of people that you would be bringing into the court might be pretty suspect to a big chunk of the human rights community, at least, and societies as a whole. So I think that, but I believe that a lot of, courtroom experience, practitioners, judges would be critical for the proper functioning of a human rights tribunal. Then you could add other considerations that could be in terms of expertise or skills that can be relevant. And my footnote on women is that generally there's this question about diversity or competence, sometimes as if women were less competent than men. And generally, I'm not blind to women in Latin America, at least. And if there are so many incredibly accomplished academics and judges and ministers, thousands. So actually, the question of having or not having women coming forward for those positions has to be explained in a different way. It's not a question of diversity versus competence in many of our countries. And his wife is, it seems to be a very good example of a prominent, smart woman in a court that there are 7 men and 1 woman. So I think that can be a false dichotomy in many contexts.
I would just add one quick question, one quick comment, and that is, on the women thing, it's a woman's experience, I mean, is, I think, unique. It's never going to be exactly like a men's experience. In the criminal courts, it showed up in that when they began, rape had never even been defined in international law. And Nave Pillay on the Rwanda Tribunal looked down at the prosecutor who was brought all these charges, and as the facts of the charges came out, she said, but why haven't you charged, a crime of rape, which of course had never been called by that name in the Nuremberg Tribunal. But it was, as a result, somebody did an article which pointed out that the 6 most prominent decisions looking to women as victims, in the criminal process, had all been brought on down by panels on which the women. And when I was there were only 2 women on the court out of 14 judges, and it hasn't gotten that much better in that particular court since. But it's there's just a completely different kind of experience there, which I think, deserves to be. I also wanted to clarify, I don't think that you have to be a judge you have to have been a judge to go on a criminal court. We don't do that in the States either. Lots of people come on cold. But I do think that the criminal process is unique in that it is so tied to certain kinds of procedural rights, and that you have to have had courtroom experience, whether you were a prosecutor, whether you were a defense lawyer, what it is, but you have to know your way around, because I saw the enormous kinds of delays, reversals, et cetera, caused by judges who just didn't understand the procedures. And the procedures are the equivalent of an international court of due process in our own courts. They're paramount, and you can't just sort of say of goodwill. I mean, we had one judge who shall go unnamed, and he really had no sense. He had full of expertise, he taught, and et cetera, but he had no sense of what a court process was like. He kept interrupting the defense counsel all the time when they were trying to question people, and they were getting it. The whole courtroom was getting agitated, and the whole thing wasn't coming together. Enough said.
Well, I hope that this panel has given us all some food for thought about what still remains to be improved and what we can do to improve it. I'd like to thank our panelists for their insightful and thoughtful remarks, and I would also like to thank Sehil and the University of Baltimore for co-sponsoring the event. And finally, I'd like to thank Mark Agrast, Sheila Ward, Wes Rist, Julia Knox, Amy Morella, and Jesse Yanko for their assistance in the organization of this event here at Tiller House. They're all an important part of what makes this a wonderful organization to be a part of. So thank you all very much for being here.
Thank you very much.
Thank you.